Thank you, Rue. I will kick things off and let's see. Just a quick, because my title was kind of interim. I'm now the deputy director of Russian Riverkeeper, and I am actually not retiring. I don't see that in my future for a while. I'm going back to my original role as working to advocate for the river, among other things, working on restoration, etc. But my role here today is really to set up the background for this case, and really talk about why this issue was brought to the county many, many, many times over many years prior to California Coastkeeper Alliance filing their initial lawsuit. As far back as 1979, there was a report done by Permit Sonoma about water scarcity in the Joy Road area near Occidental. And that report documented that as the county was permitting new wells with absolutely no review whatsoever, that they were drying up existing wells and depriving of homeowners of water for their homes. That didn't involve fish at that point, but that was certainly one of the many things that came to the county's attention, which they summarily ignored. I think really, as far as the fish impacts, those started being put squarely on the county's radar as far back as 2005. I was drawn into working with people in Upper Mark Creek about 2003, 2004. They were coming to us complaining that some new wineries at the top, the headwaters of the main stem of the West Creek on Calistoga Road, their wells were drying up large sections of the creek, and they were watching steelhead go from plentiful to scarce to non-existent. In fact, the county was given a letter by NOAA Fisheries in 2005 that called out these issues in a hearing about a winery that was associated with those vineyards in Upper West Creek. And they said, you need to pay close attention to the water use and condition this well. The county ignored that. That went to the Planning Commission. It was in front of the Board of Supervisors, and they just approved the winery and placed no restrictions on their water use. Certainly, I was in my position. People from the Mill Creek watershed, Felta Creek, and a number of other tributaries to Dry Creek, as well as Dutch Bill Creek, Austin Creek. Starting in about 2010, we started hearing more and more from people talking about new wells going in, often associated with agriculture, sometimes with residential homes, depleting streams. And certainly, we know that that's been well documented in more recent years between 2018 to about 2023 by the Sea Grant program, which was connected with the Coho Broodstock program, trying to make sure those fish do not become extinct in our watershed on our watch. And it's been well documented that riparian wells, as those wells pump, they literally you're pumping in an area usually that's alluvium, it's sand and gravel. You've got a well next to a stream. That well's usually far deeper than the stream. As that well draws water into it, it basically builds a cone of depression where water is pulled in. And essentially what happens is that pulls a stream literally down through the gravel. And it takes a stream from flowing above ground to pulling it below ground. Obviously, if you have no water, that's pretty basic requirement for fish persistence. The time when it really was rubbed in the county's face was Rue and I were both on a committee to update the riparian ordinance as part of the general plan update. And in that process, wells were brought to the county's attention. This was our current permit Sonoma director, Tennis Wick, was in charge at the time. He's still in charge. We sat in very small meetings in a room together, and NOAA Fisheries and Fish and Wildlife just said, you have to do something about the proximity of wells to streams, and you have to do something about the fact that they're dewatering streams and impacting fish habitat. They sent 2 letters to the county, very official National Marine Fisheries letters saying you're jeopardizing the continuing existence of salmonids in the Russian River if you don't address this issue. Um, Tennis was very proud of the fact that, well, he just pretty much said, we're not even going to talk about that. And thought we're doing a great job, and that's not our job. That's the State Division of Water Rights, who California Coastkeeper Alliance sued in 2008 because they get money from water rights fees, and they're supposed to be taking that money and evaluating stream flows that are associated with those water rights being issued and make sure they don't harm public trust resources. And despite winning that case, one of the streams that Fish and Wildlife was supposed to, as part of the settlement, focus on developing minimum stream flows for was Mark West Creek. That was 2008. It's 2025. They still have not completed those minimum and stream flow requirements. So both the state and the county have been notified of the issue. They've really failed at their duty as our representatives to protect our natural resources that they are the trustees for. So I think I've done my job, set the stage, and I will hand it over to our next speaker.
All right, thanks, Don. And thanks, Rue, for the introduction. I'm looking around at some of these faces. I don't know that I know any of the rest of you, but nice to meet you. I'm glad to be here. So just a little, I'm the legal director at California Coastkeeper Alliance, so I'm tasked with kind of giving you some background on the laws that applied to what the county is doing and has done in response to some of the issues that Don raised. So, many of us, probably all of us here today know or have heard of the California Environmental Quality Act, which is, called CEQA. Fundamentally, the law is intended to ensure that when government agencies make decisions, they assess, evaluate the environmental impacts of those decisions, and that they implement measures to mitigate those impacts. And that should all happen before whatever they're considering begins. And there are a few exceptions to when that full environmental analysis is required, and a couple of those, which Jamie will get to later when she talks about the lawsuit, the second lawsuit specifically, but a couple of them allow for exemptions to when the full analysis is required, and that the county implicated here. And one of them is when what they're doing is intended to protect natural resources and the environment. There's another that's just referred to kind of as a common sense exemption or common sense exception, which would be like, well, obviously what we're doing isn't going to harm the environment or have impacts, so we don't need to do the full analysis in that case. And there's more to it than that, but that kind of just gives you a little bit of an outline. And it brings me to the second sort of main legal principle that's at issue here, which is the public trust doctrine. And you can read what it says here on the slide, but basically from Roman times, in fact, and all the way through English common law and incorporated into American common law, is this idea that certain natural resources, particularly navigable waters, are protected and essentially owned by the public, and our right to use and enjoy those resources is forever ours and can't be given away. And historically, traditionally, this applied in the context of navigable waters to things like being able to um, conduct commerce over those waters, being able to fish, and reap the benefit of the resources of those waters, and being able to use those waters for navigable purposes like getting from one place to another. In California, over time, and in many places, not just California, the protections, the things that we all own about these resources include not only the waters that are navigable, but non-navigable tributaries to those waters, the aquatic resources within those waters, the recreational resources, just the preservation of those places for habitat, scientific study, and aesthetic purposes. So, what does that mean? That in California, in the 80s, there was a famous case where Audubon Society sued the State Water Resources Control Board and the Los Angeles Department of Public Works for taking too much water out of the tributaries to Mono Lake. And in that case, the California Supreme Court, clearly defined that, when the state is acting with respect to public trust resources, what I previously just described, that the state has a duty to take into account the public trust when acting, and particularly when planning and allocating water resources. And not only do they have a duty to take it into account, but they have a duty to protect the public trust uses, the fishing, the navigability, the recreation, wherever feasible, and to preserve it as so far as consistent with the public interest and the uses. And so fundamentally, this case is about what is the county's obligation when permitting the wells that Don was talking about that allocate and plan for, how water resources are going to be used. And what do they need to do to protect those public trust uses, which we focus primarily on, the salmonids and the fishery, but it goes beyond that. But that's where we had the most facts and the most evidence about what the impacts were and provided the clearest path forward. And the reason we thought we had a clear path forward is because of this previous case, Environmental Law Foundation versus State Water Resources Control Board, where in that case, which was up in Siskiyou County in Scott River Valley, which if you've ever been there, there's, a lot of alfalfa farms, a lot of farmers, use a lot of groundwater. And as they pull the groundwater out, it causes the Scott River to go dry. And there's a historical coho and Chinook salmon fishery that really dependent on that river. And they were finding, people were finding that you couldn't have both, extracting all the groundwater and the fishery. And the Environmental Law Foundation brought suit, alleging that the county had a responsibility to deal with this under the public trust doctrine because that groundwater that was being extracted was essentially the same as the tributaries in the Mono Lake case that were depriving Mono Lake of the water there. And so it extended that concept that where extraction of water implicates public trust resources, even if it's groundwater, that the public trust applies, and that counties and other people that have these responsibilities are required to comply. So there's a bullet point there that also explains that, SGMA, the Sustainable Groundwater Management Act, which many of you may know about, while it does require GSAs, which often include county government representatives, to evaluate and avoid impacts, to interconnected surface waters from groundwater extraction, it doesn't take the place of the public trust doctrine with regard to other counties and other agencies that are responsible for planning and allocating resources and groundwater resources are taking action, and that they need to comply with both. And so Environmental Law Foundation case, provided a kind of a blueprint for, if you have these types of impacts, what are counties doing to protect the public trust and, comply with their duties. And we, in conjunction with Russian River Keeper and with our overall, mission of trying to protect in-stream flows and protect ecosystems that are dependent on healthy flows and a sustainable groundwater system, we started investigating, and it turns out that for the reasons Don explained, there's a lot of information that groundwater extraction being permitted in Sonoma County is causing the precise types of impacts that Environmental Law Foundation case said needed to be addressed by the county. And so we sent the county a letter that said, you need to deal with this. They didn't respond. We filed a lawsuit. We, negotiated for quite some time in the process of, through that lawsuit of like, what is the county going to do about this? They didn't want to settle at first. Eventually, as we got closer and closer to the time for a trial there, and we started filing briefs, the county said, okay, here's what we're going to do. And they issued a, first draft of what ultimately became the ordinance. That was the focus of the second lawsuit. And that first draft, while not good enough, did present sort of a roadmap that we saw as a potential path that the county could pursue. And so we said, all right, we'll settle the current lawsuit, and on condition that you pursue that path, and that in that process you develop an ordinance that in fact does what the public trust requires. And so that led to 2 or maybe 3 county staff presenting a potential ordinance to the Board of Supervisors, the Board of Supervisors saying, we're not going to adopt that. We need a little bit more information. It involved a lot of comments from the public, from farmers, from interested parties, from domestic well users. And in November 2022, just a long time ago now, this has been going on for a while, the county issued a moratorium on well permitting, and gave staff 6 months to come back with a ordinance that it would, hope would have the information that it needed in order to support the decisions around how to protect the public trust resources. And so then in April, staff came back. During that 6-month period, there was a working group that was developed to try to figure out, what does the county need to do to meet its evidentiary obligations, to meet its duties, not only to protect the public trust, but to make decisions in a non-arbitrary and capricious manner, which Jamie will help explain in a little bit about what that means. But they convened a working group to help them try to figure out what they needed to do and what kind of information they needed to support any decisions they made. And that working group didn't include either California Coast Keeper Alliance or Russian River Keeper. It was really intended to try to focus on both policy questions and technical questions. And I think we were adversarial to the county already. And I think there was an effort by the county to try to bring in, as apparently objective people as they could into that group. During the process, also NIMS, the Natural Marine Fisheries Service, which is responsible for managing salmonids, CDFW, which Don already talked about, the State Water Resources Control Board, these folks were also brought into that group. And through the process, they pointed out to the county that a lot of the decisions they were trying to make and a lot of the things that they were looking to do were not being fully investigated, and evidence wasn't being provided to support decisions that were subsequently made. And examples of that included that there were data gaps about how much water was being extracted where and how much future water would potentially be extracted under different scenarios. There was concern about how the ordinance was being established with these, kind of exceptions for when people needed to do further analysis of whether their wells would potentially impact resources, these ministerial classifications that included, wells up to 2 acre-feet of water, which was determined to be a low volume use, but there wasn't really evidence to demonstrate that that was truly low volume. And then there was also this part about protecting public trust resources that's required that the county analyze. And the ordinance, which was adopted, requires that, conservation measures be implemented, but it doesn't define what those are, or even more so, it doesn't define what type of mitigation those conservations would be providing. And as if you look at what it says here, it's that the county's duty is to preserve so far as consistent with the public interest, the use is protected by the trust. And so that means they actually have to, demonstrate, make a showing that they're actually preserving those, and it's to the, so far as consistent with the public interest, like to the extent feasible, those types of things need to be examined, and they weren't being examined. And so, during that public process, we also, we brought all of these issues to the board's attention in comment letters, in comments, made during hearings. And, ultimately what we proposed was that, look, this is a complicated issue. It takes time to do the analysis. The analysis you've done so far is not sufficient. And so let's take this interim step of adopting the ordinance that is being proposed, but let's also do what the working group said needs to be done. Let's fill those data gaps. Let's do that analysis about those conservation measures. Let's really examine whether the ministerial classes are actually likely to not cause the impacts, or that those impacts will be mitigated. And that's what we put forth as an alternative. And the county chose not to do that. And the vote on that was 3-2. It wasn't unanimous to proceed with adopting the ordinance. So, there were still questions raised by a couple supervisors about, hey, look, maybe we should do, what's being proposed here, collect the additional information. I know we need to proceed, but we need to also commit down the line to doing more. But that ultimately wasn't the decision that was made. And so before I turn it over to Jamie, I just want to make one last point, which is the back to the CEQA issue. The board had taken the position that we don't need to do CEQA because what we're doing is going to protect public trust resources, and it's going to protect natural resources. We're doing something that's better than what we had before, which was nothing. And while that is up for debate, and I say up for debate because it's not at all clear that this ordinance actually is going to result in any greater protections for the public trust resources. Like I said, the effectiveness of the conservation measures wasn't evaluated. Are these ministerial classes really appropriate? A big issue for me throughout was that among the ministerial classes was, kind of a replacement well for an existing use and an existing volume being extracted. So, on its face, this ordinance that was adopted doesn't require any reduction in the amount of water being used and extracted from existing uses, which we already know from what Don said is causing huge impacts. And on top of that, it authorizes, without any further review, many, many, many more new wells. And so this is not a situation of like, what you're doing is clearly protecting the public trust. And the ordinance itself says it right on its face. It says, we're going to do this because we need to ensure, future domestic and agricultural water supply. And so there's this balancing going on, which the public trust is supposed to, require of the county, and which the county can make decisions under the public trust to continue to allow some impacts, but they have to do that balancing, and they didn't. And that's the same thing that CEQA requires. It requires that you do that analysis and you take a big picture look at it. And the county instead has tried to, say we don't need to do CEQA because this is just going to protect public trust resources. So kind of on its face, and we won that argument in the trial court. There's a motion for a new trial that the county has brought, which is going to be heard Friday. But the court agreed with us that is what CEQA requires, that you don't fit into these categories on their face. So I hope that was helpful. I'll turn it over to Jamie to kind of explain a little bit about the lawsuit and everything else, and then we can get into some questions.
Thanks, Trev, and thanks, Rue, for helping set all of this up. So kind of, and apologies, I'm also coming down with a cold, so if I start coughing, please ignore that for a moment. Anyways, thank you for having us here again today. But I'm gonna pick up where Trev left off. So as he noted, in May of 2023, so about a year and a half ago now, Russian Riverkeeper and California Coastkeeper Alliance jointly filed a lawsuit in Sonoma County challenging the adoption of the amended well ordinance for violation of public trust doctrine and CEQA for the reasons that Trev has kind of laid out and described for you. But essentially, our complaint largely focused on the fact that the county acted arbitrarily and capriciously in making these decisions. So essentially, because they made a lot of assumptions. They expected certain findings and outcomes. They didn't necessarily make their decisions based on concrete analysis or able to point to specific evidence. And so the court did agree with us that those decisions really for public trust analysis and CEQA, those things need to be reviewed in order to really show whether or not and to what degree the measures taken by the county would fulfill their public trust duty requirements, and whether or not those things like the conservation measures would mitigate impacts, or to what extent they would mitigate impacts. And they also didn't really get into the analysis in regards to what was feasible. There was discussion during the working group meetings about how different modeling could be done, different evidence could be brought in, and as well as like different data gaps, but the county didn't really go through the process itself of doing that analysis. It was much more procedural in regards to how they went through the working group process. So in August of 2024, so about 6 months, 5-6 months ago now, the court did rule in our favor in regards to essentially saying that the Sonoma County abused its discretion by failing to support its decisions with the necessary evidence and analysis, and that they must now go back and complete this analysis in order to establish a revived well ordinance in order to show compliance with the public trust doctrine. And the degree, like as Trev noted, we don't necessarily know what the outcome of that may be. It's just that they need to go back and do the analysis to base their decisions on. And so one of the things in regard to the public trust doctrine specifically was that traditionally there is not a like set factor, like set basis of like a procedural matrix of what factors need to be considered for public trust analysis. And so in this specific case, though, because it is circumstance specific, we were able to show that there is a need for cumulative impact analysis because of how the public trust review area was formed, and how just generally how groundwater works, in that there could be impacts more cumulatively between a high concentration of like domestic well users. There could be some sort of cumulative impact by wells outside of the public trust review area. We don't necessarily know. And so part of this is that the county needs to do that cumulative impact analysis, and that it is specifically relevant to the public trust well case that we brought. And then similarly for CEQA, the court, as Trev also noted, the county improperly relied on CEQA exemptions to essentially do it's called a notice of exemption under CEQA, but essentially because the county said that this was for the benefit of natural resources and that protections were going to be increasing, they did not have to do a full environmental impact review. And so the court determined that those exemptions relied on by the county were improper, because other factors were considered and that there were other impacts. We were able to show that via the record. And also there, because of the cumulative impact issue, that is an exception to the exemptions. And so the county needed to go back and complete that analysis as part of CEQA as well. And so based from after the court ruling, we got a judgment filed, and essentially it set aside and it directed the county to set aside and void the well ordinance amendments adopted in April of 2023. And it also directed the county to rescind the categorical exemption for CEQA and to also suspend non-emergency water well permits until the public trust doctrine was complied with. And so for non-emergency water wells, that's things like essentially anything where there isn't like a health and safety issue. Sorry, I said that backwards. So the emergency wells allow things like health and safety issues to continue to move forward under the well permit process. And because it's for water wells, monitoring wells and whatnot for like GSAs can continue to go forward as well. And then in regards to the court timeline, as previously noted, the county filed for a motion for new trial, and that is happening on Friday. And so we will have a decision one way or another at that point. And then after that, depending on what the decision is, the county does still have the option to file an appeal if they so choose. And then for a potential judgment timeline, just because we don't necessarily know how the court is going to decide in regards to the motion for new trial, it's kind of roughly by early summer, depending on how the court makes their decisions and findings, the county would have to inform the court how they plan to comply with the order. And then by roughly fall of this year, the county would file a return on the writ of mandate, kind of showing that compliance. And again, though, those are very tentative timelines because we don't know what the court is going to do. That's just if the judgment were to continue forward from roughly this time of year. So I think that's everything for me, unless Trev would like to clarify or chime in and add anything.
Thanks, Jamie. I do have one thing, just kind of like what's the situation on the ground right now? So the county, if it does decide to appeal, has indicated that it intends to seek a stay of the judgment from the Court of Appeal. And as professional courtesy, in hopes that the county would Not have to go back from like, you know, we can't issue well permits to we potentially can issue well permits again while we're appealing this. We agreed to stay enforcement of the judgment and the writ sort of through the time that the county was pursuing this motion for a new trial, because if they did win that, then the judgment would be vacated and there'd be some replacement put in place or something. And we figured, you know, for administrative ease and for other things that we would be, you know, it made sense to agree that like, okay, let's wait a month or two to between this to kind of let the dust settle. And so currently, the county is allowed to issue well permits, in at least from our perspective. Sonoma County Superior Court is really slow in like issuing orders that you can see on the docket. So we haven't actually seen that signed by the judge, but we've agreed to them that we wouldn't enforce the judgment at least until if they were issued, that they could continue to issue well permits through basically kind of the end of February. Just as kind of a procedural efficiency matter for everybody. So technically they can issue permits right now. And we'll find out on Friday what the judge has to say about their motion for a new trial. And then the clock will start ticking on all the things like Jamie described.
Okay, should I end the recording now, Prue?
Sure.
Yeah,
Okay.
it seems like a good time. I want to let you all know, well, there's a bunch of things that I want to let you all know. For the presenters, I want to let you all know that many of the people that you're looking at have been following, and some have been writing letters and approaching supervisors and other decision makers about this throughout the process. So not all of what you've said is new, although I think the detailed presentation